commissions. As we discussed earlier, there are 9 district commissions throughout the state that make the initial determination with respect to permit applications. Those district commissions are considered by law quasi-judicial bodies. They're essentially a court, a mini administrative court. Their primary obligation and role is to make decisions based on the evidence presented before them in the context of land use permitting. So that's what they do, that's what their role is. As part of that role, they also have to make certain determinations, including determinations on evidence. They have to make determinations on whether or not an application should be reviewed as a minor application or a major application. And we're going to get into that later on. But very briefly, the distinction between minors and majors is that a minor does not call for a hearing, and a major application has an actual in-person hearing. There are some other ancillary differences between the two and how they're treated, but that's the main distinction. And that's the role of the district commission. All of their decisions are appealable currently to the Superior Court Environmental Division.
For members of the district commission, are the rules, forbidding, for instance, ex parte communications apply? It's like an adjudication, and all the discussion has to be in a public forum.
That's correct. Yeah. So the way that we get there is that Act 250 currently incorporates the Administrative Procedures Act, which includes provisions for both public hearings as well as for ex parte communications.
Okay, thanks.
Sure. So we can get the next slide. Okay, so the criteria. You can go to the next slide. So there are, as you all likely know, 10 main criteria. A number of those criteria have sub-criteria, so there's a total of, I think, 32 criteria. We're not, unless there are questions about any of the criteria specifically today, we're not going to go deep into them because we could very likely spend many hours on each. But very generally, so we've got the natural resource criteria, air and water, water supply, impacts on existing water supplies, soil erosion. Transportation safety and congestion is 5. 6, impacts on schools. 7, impacts on municipal services. 8, wildlife habitat, historic sites and aesthetics. 9, impact on growth. 10, conformance with local and regional plans. So the commissions, the district commissions and the Superior Court on Appeal are essentially, their charge is to take a look at all the evidence before them and make a determination that the evidence supports a positive finding on each of those criteria. If the commission finds that each of the criteria have been met, they will issue a permit with conditions. If they find that even just one criteria is not met, they will issue a denial of the permit. Unless for one reason or another the applicant can fix the shortcoming.
Does that, on the process of getting to either an issuance or a denial, is there a dialogue that allows verification of the application and issuance of a permit with conditions, that sort of thing?
Sure. So if there were a significant dialogue to happen, it would be during a major process, during the hearing, essentially. There's opportunity to respond to evidence, cross-examine evidence, submit your own evidence if you're a party.
Can you say something about the 10 criteria and how they compare to all the criteria that lead to a designation? So for instance, one of the questions that we're going to end up facing is, if you're in a designated area, might you sort of have, in a way, pre-permitted on a number of things because they've already been considered as in the process of earning that designation? So I'm wondering if all the designations mean that all 10 criteria, any designation means all 10 criteria have already been examined. Maybe they get re-examined in a more particular way for a particular application, but do we ever lose examination of any of the 10 criteria if we go into the designated process instead?
Yeah, that's a very good question. And the short answer is that the designation process, and I think you're referring to the 5 state designated centers, designated downtowns, growth centers, new town developments, neighborhood development areas, and village centers. They're an array of designations for which each have certain benefits. And the short answer is that it's not a zero-sum game. The designation process does not look at all 10 criteria. It looks at some, but it's not as if the designation process looks at the Act 250 criteria and says, okay, this is how we're going to deal with transportation, this is how we're going to deal with public infrastructure. It doesn't quite work like that, and there are some criteria, and I can't today provide you with a definitive list, but there are certainly some criteria that are not addressed in the designation process. Sure.
But that is moving now also, so there is conversation
Another
about
flag.
Yeah, another flag.
Yeah. Burden of proof. So generally speaking, the applicant always. So now we're talking about what evidence the commission is going to be looking at, and who bears the burden for which criteria. Generally speaking, the applicant is always going to have the burden of production. The applicant is always going to have to submit enough evidence to the district commission so that district commission can make a decision one way or the other on each of the criteria. The applicant retains the burden, the final burden of proof or persuasion with respect to most of the criteria, 1, 2, 3, 4, 9, and 10. If there is an opponent to a project, that opponent would bear the final burden of persuasion with respect to criteria 5, 6, 7, and 8. And once the commission reviews all of the evidence, takes all of the testimony that it deems necessary, it will ultimately issue a decision. If the decision is issued and a permit is issued, the permit will always include conditions that help the project meet the criteria. So we can move now to the next slide. So Act 250 is a citizen-based project review process, as you all know. We can go to the next slide. And part of that process relies on input from other entities besides the proponent of the project or the developer. And there's a couple of different mechanisms that Act 250 has to get at that additional information that might be out there. One of them is by way of party status, and we can move on to the next slide. Party status is the legal mechanism that allows entities to participate in the fund and to submit evidence and to cross-examine evidence and to act as a party in the proceedings. It's the law. Act 250 is based on this idea of citizen participation. And ultimately, if party status is done in a way that is, if a broad enough approach is taken to party status, it allows commissions to receive as much information as they deem appropriate. And ultimately, if parties participate in a constructive way, at least theoretically, that should avoid delays and appeals and remands and the like in an effort to make the process as efficient as possible.
Amongst parties, how can you characterize how many parties are actually there? As it's a citizen who comes in and just voices sort of in non-legal language, you know, a concern about a project versus a more formal representation by lawyers in the process.
Sure. Yeah, you know, I think we're going to hit on that in a couple of slides. So,
sure.
And if I don't answer your question, we'll remind me and I'll try to hit it again.
Let's keep going.
So the current Act 250 allows for certain statutory parties. These are parties by right. They're automatically parties. They may participate. They may choose not to participate. Those parties are the applicant, the landowner, if the landowner is not the applicant, the municipality in which the project is located, and municipality and regional planning commissions for that municipality, municipalities and regional planning commissions adjacent to the project, and any state agency that might be affected by the project. And before we move on to the next slide, I want to just touch on this piece, because this is important. So generally speaking, the state agencies that we might see participate in the project are the Agency of Natural Resources, the Agency of Agriculture, Department of Historic Preservation, and Agency of Transportation. Thank you. There are others, but those are, I would say, the four most common players in Act 250 permitting matters, and they all provide invaluable resources to the Act 250 district commissions by addressing certain issues that may not be obvious to the district commissions concerning their areas of expertise. Among those four agencies or state entities, I think it's fair to say that the Agency of Natural Resources probably plays the most significant role with respect to the five natural resources criteria. And they often participate by way of reaching out to the applicant even sometimes before an application is filed, sometimes during the application process, itself before a matter goes to the hearing. And the agencies really act in many ways as experts for the state, so that they can provide feedback to certain aspects of any given application, and then ultimately they can provide that evidence to the district commission. So it's an important process that plays out, and there's oftentimes a lot of back and forth between the agencies and the applicants, and sometimes I don't think that's recognized by folks who are not intimately involved in the Act 250 process.
How is it that A&R, for instance, will be aware of a project before it's actually had an application filed? How do they?
Yeah, so that's a good question. There's a couple of ways. Number one, there might be an ancillary permit. So for instance, the agency might be in the process of reviewing a permit application for a wetland or a stormwater project or a wastewater program, and they will know that project will trigger Act 250, and so they can start working with the applicant pretty early on while the applicant is obtaining those ancillary A&R projects or permits. And the other way that comes to mind is, especially for the more seasoned consultants, before an application is even filed, it's more than, and the project is known to have some concerns, some natural resources concerns. It's more than likely that the consultant will reach out to A&R staff to discuss what the issues might be and to see whether or not there might be a solution to the problem even before an application is filed. And so when the process works like that, you end up with a better application, and you end up with a better process at the end of the day, because the application is already vetted and it's more complete, and it makes it easier for the district commissions to review. Yes, and so there are also there is a mechanism called a project review sheet. Whenever a developer is in the process of going through an ancillary permit, so for instance a stormwater permit, that triggers the need for a Act 250 district coordinator to review what's called a project review sheet, which is essentially a request for a jurisdictional opinion. When they see the project review sheet, which includes a brief description of what the project is, the district coordinator will make a determination as to whether or not the project needs an Act 250 permit as well.
And just if I may, that involves also the permit specialists who work for A&R. So when somebody needs a wastewater permit specifically, a PRS will be filled out, and that goes to the coordinator, and then there's a collaboration going forward on jurisdiction.
So if you're not one of these statutory parties, how do you become a party? How do you get party status? And the statute that governs party status says any person who has a particularized interest protected by this chapter that may be affected by an act or decision by the district commission will be a party. The standard that's developed out of that provision over time is that an aggrieved person need only show a reasonable possibility that a decision on the proposed project may affect a person's particularized interest. So that's really what the district commissions have to look at with respect to a request for party status. In practice, what happens, an individual might become aware of an Act 250 application either by way of word of mouth or by receiving notice, either actual notice in the mail if they're an adjoiner, or by reading about a proposed project in the newspaper, or by seeing the notice in their town office. If a person feels like they are aggrieved and want to participate in the process, they have to file a petition for party status, either directly with the district commission in advance of the first hearing, or it can be done orally at the first hearing. The commission will review the petitioner's concerns and make a preliminary determination on party status. So, and more often than not, and I don't want to say always, but more often than not, the commission is likely to grant preliminary party status, which grants an individual or an entity the right to participate at the hearing. At the end of the hearing, the commission will revisit its decision and make a final determination as to whether or not this individual or entity should have been granted party status.
So I'm thinking about something like the state's policy around having high quality waters where you can swim, fish, all that kind of stuff.
Sure.
If I'm right next to a proposed development, you would be in a butter, so you get party status, right?
Adjoiners get notice. They don't automatically get party status though, and that's sort of a misnomer.
Okay.
I think there's a number of people think it's automatic party status, and that's not quite how it works.
Okay, so notice, but not necessarily party status. So would I need to say, I'm concerned, I swim in this, I fish in this,
Yes.
and this could affect the quality of the water, so that would be your...
Absolutely, and more likely than not, that would be a sufficient petition for party status. So the elements are the red underlines in the first one. They're you're a person. You've defined what your particularized interest is. You fish, you swim in the river, and you'd be affected, at least presumably, by the project. So I think that you would probably pass the test to participate.
And he would have to specify which criteria.
Correct.
Okay, and how closely, if I'm a mile downstream, can I still come forward?
You can. If you use that water and you still have the particularized interest and you're affected, you can still make that argument. And I think the piece that the commission's going to be concerned about at some point, depending on how far away you get from the project and how often you use it, that's going to be maybe the defining factor. But if you're using that water source, the water body regularly, or even once in a while, the commission is more than likely going to grant party status.
Does residency make a difference?
No.
So you could be visiting. That's what I'm talking about. With regard to, you're coming over the border from New York to fish in that part of the Woonsocket or the Battenkill, doing it regularly during fishing season.
So, yeah, and you're not a Vermont resident.
Not
You
Vermont
come
resident.
regularly. I don't want to get into hypotheticals too deeply, but I think that would be a good case for party status in my opinion.
Oh, and I asked about water because we talked about water is being held in public trust and shared by everyone, so I didn't know how far that connection through water and shared interest would reach.
Yeah. Yeah, and I think the chair was also making a really important point that I just want to drive home here. So any person or entity that is requesting party status does have to be specific about which criteria they're requesting party status for. And because you're granted party status on criteria 1 and 4, does not mean that you are granted party status on transportation criteria 5. If you want to participate in a certain criteria, you must seek affirmatively party status for each of those criteria that you want to participate.
Thank you.
And I was just going to say, if you do gain party status, you can then appeal, but again, you have to appeal based on the specific criteria that you were given party status.
That's right. And then we just sort of highlighted the elements again in this slide, which we just went over. Any person, and any person is not just a person, it's also an entity. It could be a business, it could be a nonprofit a nonprofit entity.
It's the any person / corporate
Right.
definition we've all wrangled with.
Particularized interest and affected by the project. And I've already went over final party status. Okay, next slide.
If you did obtain final party status, that's, I mean, you participated, but then with this, in a way, we're gonna, I don't know what they do, they say we're going to now disregard the information you brought because you actually determined you weren't a party.
That's correct. And the other point is, if you were denied final party status, you lose the right to appeal the decision, except you could appeal the decision on final party status. So the application review process, this is sort of like the nuts and bolts of how the process works.
Very bare bones.
Bare bones. Yeah. I mean, there's a lot to the process. This is the bare bones. So an application, presumably the developer has spent some time drafting a complete application with all the necessary exhibits and the check for fees, and submits it to the district office. The district coordinator reviews the application to determine whether or not it's complete and sufficient to be reviewed by the district commission. That is supposed to happen within 7 days. If the coordinator finds for one reason or another that the application is incomplete, that can be appealed, and it's considered a jurisdictional opinion for purposes of appeal. That does not often happen, but
usually what happens is the coordinator sends an incomplete letter to the applicant and says you need these things to be added to your application to make it complete.
That's right. Once the application is deemed complete, the commission has 10 days to determine whether to treat the proposed project as a major or a minor. And again, the distinction there is the minors don't have hearings. They have a comment period, but no hearings. A minor can turn into a major if someone requests a hearing, or if for one reason or another the commission on its own decides, hey, this should really be reviewed as a major. No, that's fine. So either minor or major. If an application is to be reviewed as a minor, notice and the proposed permit are mailed and published to all of the entities and people that are required to get notice by statute. There's a 20-day comment period during which an entity can request a hearing, and then the commission would make a decision on that request. If no hearing is requested, a final permit is issued thereafter. If a hearing is requested, we move into the major process.
Although a commission can deny a hearing.
Do you
Request for hearing.
also have to, if you're asking for a hearing, do you also have to be asking for party status?
Correct.
If you're, sorry,
Oh, go ahead.
if you're not given party status, are you unable then to call for the hearing? Because you can say, well, you don't have party status, so we hear that you want a hearing, but we still don't think we need one. And the process keeps going.
Yeah, so they're two separate determinations ultimately, and the commission will likely look at the issue of whether or not there should be a hearing first, and as part of that decision, the commission is going to be looking at some of the issues that are raised, assuming the person requesting a hearing raises the appropriate issues. Those are going to be reviewed and weighed as part of the decision as to whether or not a hearing should be granted. The commission will then take up the issue of party status more than likely after a decision on a hearing is made. That was a good question. So, provided the application is being reviewed as a major, notice is mailed and published in the newspapers within 10 days of filing a complete application. There must be a hearing or a pre-hearing or site visit within 40 days of filing a complete application. Ultimately, there will be a hearing. The hearing is, more often than not, a morning or an afternoon or sometimes an evening. On occasion, hearings last for more than one day. They might be 2-3 days, but that's somewhat infrequent. It happens from time to time. Once the hearing itself is adjourned, the commission might determine, or I should say more often than not, will determine that it needs additional information. It will issue what's called a hearing recess order within 14 days of the final hearing. And that typically asks for more information. Applicant, can you provide XYZ? Can you, or neighbor, you express concerns on this. Can you please clarify your position? Once those items that are requested are filed back with the district commission, the other parties will have an opportunity to respond to those items that were produced by the other parties. And once all of those items have been filed with the commission, and the commission had a chance to review the items, the commission will issue a permit, or assuming that it is willing to issue a permit and not denying the project, it'll issue a permit as well as findings of fact and conclusions of law. We can go to the next slide. So this slide I included. I have a sense that you all likely know what happens at a hearing, especially after our discussion just now.
Yeah, and senators have lots of hearings.
Yeah, exactly. Senators, you all have lots of hearings. So it's an opportunity to present evidence, cross-examine witnesses. It's an opportunity for opponents of the project to ask questions. It's an opportunity for the commission itself to ask questions on clarity and so forth. But it's a hearing, not unlike any of the hearings that you've been to.
Is there back and forth so that through the chair or whatever, but that if neighbor A says, I'm worried about this feature, that the applicant is allowed to then respond to that concern so that you work your way through some of the issues in real time?
The design of these hearings are relatively informal, and so there might be a little bit of variability between commissions and how chairs of the commissions like to handle their hearings. But I would say more often than not, it's a relatively informal process, and that sort of dialogue could be helpful. So I would imagine more often than not, it would be allowed. So long as you're staying within the confines of the criteria that are issued, right? Commissions wouldn't want to explore items that are not among the criteria. It's a relatively small universe of issues that can come up. So decisions and permit, applications are either approved or denied, and whenever they're approved with conditions. And like I was saying earlier, major decisions will include both the permit itself and the findings of fact and conclusions of law. All of those items, the findings of fact, conclusions of law, the permit itself, they're all appealable to the Superior Court. Environmental Division, again, that's something, picture we want to flag for you. If a permit is denied, it can be appealed to the Superior Court. Permits run with the land. They don't just live on for the duration of the construction or operation of a given project. They own the land indefinitely. Flag, that's something that the House is looking at, maybe making some changes to. We can go to the next slide. I think this might be the final or second to last slide that we have in the PowerPoint. This just talks about what's appealable, and you know, the big picture here is any decision by the District Commission is appealable to the Superior Court Environmental Division, and the court looks at those appeals de novo. Big flag on that one. There might be some changes proposed. The idea is, for those of you who may not know, a de novo appeal allows the reviewing body to look at the case brand new, as if there was no decision issued below. The Superior Court Environmental Division on appeal will take brand new evidence, and there is no deference at all to the decision that the commission may have issued. So it's a brand new trial. Just one point of clarity though, if an appeal is taken on a permit, it's typically taken on only one or at most a handful of criteria. So it might just be criteria 1G, wetlands and traffic concerns that a party has. And so the appeal will be confined to those two criteria. The court won't open up the entire issue, the entire decision that the commission made. Only the criteria that are appealed.
So it's de novo, but only for the criteria?
That's correct. That is correct. I've just listed a bunch of resources here. We don't have to go through these, but we have quite a few resources on our website. If any of you have extra time and are interested in learning more about Act 250, you should feel free to.
Extra time.
Yeah.
It's like extra money.
Senator Perry.
And so if there are, I was going to say, Chair, if you don't have anything to add, maybe we open it up for questions.
Oh, absolutely. Yeah. Clarifications, questions, statements. I did want to go back to your question, Senator McDonald, about the difference between 1970 and now in terms of how many applications come from, and if this is not what you asked me, please let me know, but how many applications come from out-of-state corporations? Is that the question?
Yes.
Okay. Right. And I gave you an answer which is my belief. On the other hand, I have not done any research to understand that. So I still feel as if, based on what I see of applications, that the majority are Vermont-based companies. But that doesn't mean there aren't an increase also in corporations.
I made a list of,
Thank you.
which was just a stream of businesses that are operate in Vermont today. And then my question was, if you look for these businesses 50 years ago, how many of them would we recognize?
Right. I think I've seen a version of this list before.
This is not,
Senator.
this is the copyright on this is
Yeah.
not expired.
Okay. But it's an excellent question, because I mean, if you think about, for example, dollar stores, and a lot of people have said to us, why can't we stop this?
Dollar Tree, Dollar Store,
Yeah.
Christmas Dollar.
That they
Family
say, well,
Dollar
we
General.
don't want
Dollar
this.
General, that's four
But-
different dollar
But the
stores.
fact of the matter is that lots of people shop at them, and
That's
I've
true.
heard a variety of people say, well, they have the best prices on this or that or
Oh,
whatever.
that's also true.
Right, and there isn't any way that Act 250 can target a particular type of development and say this can't happen
Well,
unless it's in a town plan or zoning or, okay.
My question was, when someone comes into the Act 250 hearing, are they speaking as a local, is one would have expected them to speak 50 years ago when they owned a business and lived here and had a view of how Act 250 was supposed to work? Or did they come in now saying, my board of directors in Lexington, Kentucky, or South Carolina, or Tennessee have directed me to say?
I would tell you that
That's basically what I was looking for, how that differences has played out over the last 50 years as we seek to review Act 250, recognizing the 50 years of change that has taken place.
I will tell you, there are certainly more consultants than there used to be.
In the State House.
Of all variety.
Your opening remark that the majority of applications are by Vermonters and Vermont issues, that maybe you would look at the ones that, which group had the appeals all coming disproportionately from the traditional applicant, or the new groups, or by dollar figure, are they coming from, where are they showing up? What's changed?
A couple of numbers that I wanted to just put out for you that are of interest.
Are in the annual report that I.
That are of interest to you, probably are of interest just right now, regardless of whether or not Act 250 is going through some potential changes, but some things to think about.
72% of our permits are processed in 60 days or less. Okay, that is primarily administrative amendments and minors. Majors do take longer, but I say that just for people.
60 days or less.
Yes, that's a significant amount of.
No, I think that's very helpful. There's a lot of urban legend around there.
Yes, there is, yes.
And so I think, and I've heard that before, and I appreciate hearing it again.
The urban legend usually comes from the horror stories that go on for years and years, which
Right.
take the average.
And I like to say that was the way it used to be. And now the way it is at Act 250, we really care about each and every project. We have systems to prevent that if something falls off the so-called assembly line, that we find it and pick it up and put it back on and make it go. So we've really focused on being as effective and efficient as we can.
And some other numbers that you might consider are the number of appeals that we typically see in this past year, calendar year of 19, there were a total of 14 appeals to the Superior Court. 8 of those were appeals from district commissions. 6 were from coordinators on jurisdictional opinions. And one other number that you'll sort of see in the report, though the aggregate number is what I'm going to give you. Over the course of the last 5 years, the average number of majors, so projects that require hearings, have been 40, right around 40 majors a year across the regions on average for the last 5 years.
It's not appeals in 40, but
No,
it
just major decisions. Yeah,
Major applications.
Projects that required a hearing at the district commission level for which a decision was issued.
And the rest of it just
The rest, so the rest were minors. So permit issued without a hearing, or administrative amendments, which are even typically processed even quicker than a minor, and that's.
I think 96% are done in 30 days or less.
So quite a high percentage of our applications are processed as administrative amendments.
So, and just not to belabor it, but yes, majors do take longer. So, and I think I would ask the committee, in considering that, to remember that the point is to have an appropriate review, to consider carefully what the impacts are, not to do it as fast as possible.
When you were a member of this committee, one of the things we worked on was permit reform. And I think in a way it was, we were piloting concepts as with an eye towards possible Act 250 reform. So I don't know if you've seen permit reforms, not necessarily within Act 250, that you, for instance, de novo on the record, or that make you think, well, now that you've witnessed that happening, you would also recommend changes for Act 250 itself on the appeal process.
I would just say that I think I live with permit reform every day, Senator, in that, there's a constant need to improve the process, but also it is in improving the communications with the Agency of Natural Resources, because we have no control, essentially, over how long it takes them to prepare their permits, and we wait for those permits to come in before our permits can be finished. So that's an ongoing, dilemma, if you will, that we need to have better communication on how those things work and better information to the public about when you should apply for your A&R permits in combination with an Act 250 permit.
And I think that's where a lot of the bad reviews come. A lot of people get the two mixed up, and they go to your shop and they think they're all set, and then they find out they need this other permit that hangs them up, but the whole thing gets lumped under Act 250 took so long.
Right.
A lot of it is those permits.
And I see that very much as our obligation to inform people better. I mean, it's a big task, but I do think that it's about people understanding the process better. And I don't want to put any blame on anybody. It's about making that work for the applicant. So.
And A&R needs to also, because they have so many different departments and so many different permits, they need to do a better job informing the public when they come in. And these are all the different things you're going to need. These are all the different people you got to go talk to.
Does an application have to have all its its A&R permits in hand in order to make an application? Or will that?
No, you can have submitted your application for an A&R permit, and the Act 250 permit can proceed, but you have to have them all in hand before a permit can be issued.
The applications for those other A&R permits.
Yeah, you have to have. You can start a Act 250 application if you have only applied for your A&R permits, but you must have the final A&R permit to have an Act 250 permit issued.
Okay. There's a very slight nuance to that, though, that I just want the committee to be aware of. And the chair is correct. The only 99% or maybe even more of the time when an ancillary A&R permit is needed for an Act 250 project, the applicant is going to rely on that permit for a presumption of compliance with whatever criteria that permit may cover. So for instance, if an applicant needs a wetlands permit from the Agency of Natural Resources, the applicant can rely on that permit for compliance with Act 250 criteria 1G, in which case the applicant will need to produce the permit in hand before an Act 250 permit is issued. The one exception to this, and this doesn't happen often, but applicants can rely on evidence that they comply with 1G without having the benefit of the wetlands permit. It means that the applicant has to go through this process twice. They have to put on evidence, they have to submit evidence to the wetlands program, and then they'd also have to submit evidence on wetlands to the Act 250 District Commission, and the commission would make up its own mind based on the evidence presented with respect to wetlands. So in that scenario, and again, it doesn't happen often, in that scenario, the commission would not need the ancillary A&R permit.
Okay. And when you refer to the approval process to rebuttable presumptions, is each permit does that create a rebuttable presumption that you've met a criterion, or are those apples and oranges?
No, that's. I think the way you stated it, if I heard it correctly, is the way it works. And by the way, we'll put a flag on that one as well. Although I didn't bring up presumptions directly in the presentation, that's also another area.
Is it Rule 19?
It's Rule 19, yeah. So
that means some of the A&R permits are rebuttable presumptions, not necessarily all of them.
That's correct. And for the specific criteria that it might address. So the wetlands permit. I mean, the big three that I think we see most often are wastewater, wetlands, and stormwater, but there are certainly others.
So we appreciate the opportunity to speak with you today. We don't want to take any more of your time unless you have more questions, and we look forward to coming back when perhaps you have a proposal for changes.
Thank you.
I do have a question about what we might, well, no.
I'll just tell you the biggest change that is being proposed at the moment is a change in the structure of the board itself,
Right.
which is to make it a professional board. There are several variations going on, so I can't really speak to what that will be, but I will tell you that a professional board, I think, has a lot of merit. So,
Okay. Thank you.
Thank you all. Please let us know if you would like us down again for a visit.
We will come.
Like it or not.
I-
Thank you.
You never know. Around here, I would say, in this case, I'm sure we'll be inviting you to come back.
Thank
again.
you.
Thank you.
Have a good day. Thanks again. So, committee, that was our last witnesses for the morning. And, stay tuned. Anything else anyone wanted to bring up around permits, Act 250, et cetera? Okay, then we are adjourned.